The controversy began when a video surfaced online showing a judge aggressively scolding a young boy, allegedly for disrespecting court procedures. Witnesses claim the boy, who appeared to be no older than 12, was visibly shaken as the judge raised her voice, calling his behavior unacceptable. Some legal analysts argue that while judges have authority to maintain order, the tone and manner of reprimand seemed excessively harsh. The clip quickly spread across TikTok, Twitter, and YouTube, with millions debating whether the judge crossed a line or was simply doing her job. Supporters say she upheld courtroom dignity, while critics accuse her of bullying a child. Legal experts are divided on whether the judge will face repercussions. Some state that judicial immunity protects her from lawsuits, but ethical complaints could lead to disciplinary review. If evidence proves she violated judicial conduct rules, such as showing bias or undue cruelty, she might receive a reprimand or even suspension. Meanwhile, the boy's family is reportedly consulting lawyers about possible civil action. The case has also reignited calls for court reforms, including mandatory sensitivity training for judges handling juvenile cases. Whether this incident becomes a turning point or fades away depends on public pressure and media attention in the coming weeks. Behind the viral outrage lies a deeper question: what led to this confrontation? Sources close to the case reveal the boy, identified as 11-year-old Jason M., was in court for a minor school-related incident, reportedly a misunderstanding over a stolen lunchbox. His family claims he has ADHD and struggles with anxiety, which may have contributed to his perceived disrespect in court. Child psychologists warn that traumatizing interactions with authority figures can have long-term effects, especially for neurodivergent children. Meanwhile, educators familiar with Jason describe him as a quiet kid who's never been in serious trouble, raising concerns about whether the judge's approach was proportionate. This context has fueled even more anger online, with many asking, did this child really deserve such treatment? The incident has reignited debates about systemic failures in juvenile justice. Statistics show that Black and Latino children are disproportionately punished in U.S. courts, and while Jason's race hasn't been disclosed, activists argue this case fits a broader pattern of harsh treatment toward marginalized kids. Reform advocates point to states like California, where restorative justice programs for minors have reduced recidivism without courtroom intimidation. Critics of the current system demand mandatory bias training for judges and better protections for children in legal settings. As one law professor put it, a courtroom shouldn't feel like a battleground for a child. Whether this viral moment leads to policy changes or fades as just another internet outrage remains to be seen. The case has become a lightning rod for media polarization. Conservative outlets frame the judge as a strict disciplinarian, maintaining order, while progressive platforms condemn her as a tyrant abusing power. Cable news segments feature heated debates between legal analysts, with some arguing the footage was edited to manipulate viewers. Meanwhile, independent journalists dig deeper, uncovering past complaints against the judge, including two similar incidents last year involving teenage defendants. The family's decision to remain silent has created an information vacuum, allowing speculation to run wild. This media circus raises important questions about how high-profile legal cases should be covered, especially when minors are involved. Some experts warn the constant coverage could re-traumatize the child, while others argue sunlight is the best disinfectant for judicial misconduct. Social media has transformed this local courtroom incident into a global controversy. Change.org petitions demanding the judge's removal have gathered over 250,000 signatures. TikTok activists have created explainer videos viewed millions of times, often simplifying complex legal procedures into emotional sound bites. The judge's professional history has been dredged up online, with users sharing every controversial ruling from her 15-year career. While this digital activism has kept pressure on authorities, it's also led to dangerous doxing attempts against both the judge and the boy's family. Legal scholars worry about the court of public opinion overriding actual judicial processes, noting that internet outrage rarely leads to substantive reform despite its immediate intensity. Beyond the viral moment, this incident may become a landmark case for judicial reform. 3 state legislators have already proposed Jason's Law, legislation that would require special training for judges handling juvenile cases and mandate child advocates in all courtrooms. The American Bar Association has announced a review of judicial conduct guidelines regarding interactions with minors. Perhaps most significantly, the case has inspired hundreds of parents to come forward with similar stories of their children's traumatic courtroom experiences. While the judge's fate remains uncertain, her next disciplinary hearing is scheduled for September. The lasting impact may be a systemic reckoning with how America's legal system treats its youngest and most vulnerable participants. As one reform advocate noted, this wasn't just about one bad day in court. It's about exposing a broken culture that's existed for generations. Child psychologists are sounding alarms about the potential long-term psychological damage caused by such courtroom encounters. Dr. Emily Stanton from Harvard's Child Trauma Institute explains, public humiliation from authority figures can fundamentally alter a child's brain development, leading to PTSD, anxiety disorders, and distrust of legal systems. The boy's school reported noticeable behavioral changes post-incident, increased nervousness, difficulty concentrating, and nightmares. Meanwhile, his parents have reportedly sought emergency therapy sessions. This case highlights the absence of mental health professionals in juvenile court proceedings, with only 12% of U.S. courts having on-site child psychologists. The American Psychological Association has issued new guidelines urging courts to consider developmental psychology in all cases involving minors. Investigative journalists have uncovered 17 similar complaints about Judge Henderson's conduct over her 22-year career, though none previously involved children so young. Court transcripts reveal a pattern of impatient behavior, particularly with self-represented defendants. Interestingly, her judicial evaluations show perfect scores on legal knowledge, but consistently low marks for temperament. Colleagues describe her as brilliant but inflexible, with one anonymous court clerk admitting, she views any challenge to her authority as an attack on the judiciary itself. Legal ethicists debate whether this incident reflects personal failings or a broader cultural problem in America's overburdened court system, where judges face 300-plus cases monthly with little oversight. The local community has organized Justice for Jason rallies outside the courthouse every Friday, drawing hundreds including teachers, pediatricians, and religious leaders. A coalition of 35 child advocacy groups has launched a national campaign called Bench Respect, demanding judicial reforms. Surprisingly, the movement has gained support from unexpected quarters. Several retired judges have joined calls for mandatory de-escalation training. Meanwhile, the National Sheriff's Association surprisingly endorsed reforms, with spokesperson Mark Wilson stating, "We've learned de-escalation tactics. Why shouldn't judges?" The City Council has fast-tracked funding for a juvenile court liaison program, while 3 law schools have announced new clinics focused on children's courtroom rights. Comparative law experts highlight stark contrasts with other developed nations. In Norway, judges receive specialized training in child development and always hear juvenile cases in private chambers with social workers present. Canada's Youth Criminal Justice Act mandates that proceedings be conducted in language comprehensible to the young person. Japan employs child judges who explain procedures in age-appropriate terms. Even Texas, not known for progressive reforms, has successful programs where judges remove their robes and sit at eye level with young defendants. These international examples fuel arguments that America's adversarial approach to juvenile justice may be doing more harm than good, especially for nonviolent offenses. Beyond moral arguments, economists warn about substantial financial impacts. Studies show children traumatized by legal systems are 63% more likely to require special education services, 40% more likely to need mental health interventions, and 3x more likely to have future justice system involvement, creating lifetime societal costs exceeding $1.2 million per child. The CDC estimates adverse childhood experiences, including judicial trauma, cost the U.S. $748 billion annually in healthcare, education, and criminal justice expenses. Business leaders have surprisingly entered the debate, with the U.S. Chamber of Commerce noting, workforce readiness begins with how we treat our children, including in courtrooms. Some states are exploring justice reinvestment models where prevention funding reduces future costs. Amid the controversy, hopeful developments emerge. The case has inspired law students nationwide to specialize in juvenile justice. Applications to related clinics have tripled. A tech startup created Virtual Court Buddy, an AI tool helping children understand proceedings. Most remarkably, Judge Henderson, while still facing disciplinary action, has reportedly begun mentoring new judges on child-appropriate courtroom conduct. The boy's family, through their attorney, has advocated for using this moment to help others rather than seeking revenge. As the National Council of Juvenile and Family Court Judges observed, sometimes change requires a catalyst, however painful. This painful incident may ultimately prevent countless others from similar trauma, fulfilling the judicial system's highest purpose: justice that protects, not punishes, the vulnerable. The incident has sparked nationwide discussions about preparing students for legal encounters. Several school districts have implemented Know Your Rights workshops specifically designed for children as young as 10. These programs teach students basic courtroom procedures, how to interact with authority figures, and when to request legal representation. Educational psychologists emphasize that such training should be trauma-informed, avoiding scare tactics while building practical skills. Some innovative schools have even created mock courtroom simulations where students role-play different positions in a safe environment. Teachers report these initiatives not only prepare children for potential legal encounters, but also improve overall classroom dynamics by demystifying authority structures. The Department of Education is considering making such programs eligible for federal safety grants. In response to this case, tech developers are creating innovative tools to help children navigate legal systems. A Stanford-led team developed Court Comfort VR, a virtual reality program that familiarizes kids with courtroom settings through gamification. Legal aid organizations have launched chatbot services like Rights Buddy that explain legal concepts in child-friendly language via text messages. Perhaps most impactful is My Court Story, a digital platform allowing children to preview and practice answering common courtroom questions with animated characters. These technologies address the power imbalance by giving children a sense of control and predictability. Early studies show such tools can reduce courtroom anxiety by up to 72%, though experts caution they should complement, not replace, proper legal representation for minors. The case has revealed stark generational differences in attitudes toward authority and justice. Baby boomers and Gen Zers are significantly more likely to support the judge's strict approach, 42% approval in polls, viewing it as necessary discipline. Millennials show mixed reactions, while Gen Z overwhelmingly, 83%, condemns the judge's behavior as abusive. Social media analysts note this mirrors broader generational shifts in parenting styles and educational approaches. Older attorneys recall when judges routinely shouted at defendants as standard practice, while younger lawyers describe such behavior as unthinkable today. This divide complicates reform efforts, as many sitting judges belong to generations that normalized adversarial courtroom behavior. Judicial training programs are now incorporating intergenerational dialogue sessions to bridge these perspective gaps. The viral nature of this case has highlighted the need for better media literacy education regarding legal matters. Nonprofits like the Center for Youth and Media Justice have developed curricula teaching students to critically evaluate courtroom footage, understand editing techniques, and recognize sensationalism. A particularly effective lesson compares multiple news outlets' coverage of the same legal incident, revealing how framing shapes perceptions. Some schools are inviting journalists to explain how they report on juvenile cases while protecting children's privacy. These skills help young people navigate the complex media landscape surrounding high-profile legal cases, separating factual reporting from opinion or manipulation. Experts suggest such training could prevent future viral incidents from causing secondary trauma through irresponsible media coverage. This incident has become a flagship case for restorative justice advocates. Unlike traditional punitive systems, restorative models focus on repairing harm through dialogue and mutual understanding. Pilot programs in several states now allow qualified juvenile cases to be diverted to community circles where all participants, including authority figures, sit as equals. Early results show 68% fewer repeat offenses compared to traditional court processing. Surprisingly, Some of the strongest supporters are police officers who've participated in these circles. You can actually see the moment when a kid realizes they're being heard as a person, not just judged as a case number, observes Officer Maria Gonzalez, a 20-year veteran. While not appropriate for all cases, these approaches offer promising alternatives to adversarial courtroom confrontations. 1 year later, what began as a traumatic incident has evolved into a national movement for juvenile justice reform. Jason's principles, a set of child-centered courtroom guidelines, have been adopted by 14 states. The federal judiciary has allocated $45 million for trauma-informed training for judges and court staff. Most remarkably, the boy at the center of the storm, now protected by anonymity as he enters adolescence, has become a symbolic figure for change, though his family maintains their privacy. His story features in law school curricula and judicial training programs nationwide, not as a case study in conflict, but as a lesson in the profound impact courtroom interactions can have on young lives. While the work remains unfinished, this painful chapter may ultimately humanize America's justice system for generations to come. Law schools across America are overhauling their curricula following this incident. The American Bar Association now requires all accredited programs to include child development psychology courses for judicial track students. Innovative programs like Georgetown's Compassionate Jurisprudence initiative teach future judges emotional intelligence techniques, including tone modulation and nonverbal communication. Perhaps most significantly, aspiring judges complete mandatory internships at youth centers before donning robes. These reforms aim to prevent future courtroom trauma by creating a new generation of judges who view their role not just as arbiters of law, but as stewards of vulnerable participants' well-being. Early results show promise, with students reporting greater awareness of how their words and demeanor can impact children in legal settings. The case spurred creation of comprehensive support systems for families navigating juvenile courts. Free Court Companion programs now operate in 32 states, pairing families with volunteer legal guides who explain procedures in plain language. Pediatricians receive training to identify court-related stress in children and make appropriate referrals. Perhaps most impactful are the family legal prep workshops offered at community centers nationwide, teaching parents how to prepare children for courtroom appearances without causing undue anxiety. These resources help demystify legal processes that once seemed intentionally opaque to non-lawyers, empowering families to advocate effectively for their children's rights and emotional well-being throughout legal proceedings. Major corporations have surprisingly emerged as champions of juvenile justice reform following this case. Tech giants fund digital literacy programs about legal rights, while retail chains host Know Your Rights seminars in underserved communities. Perhaps most remarkably, 20 Fortune 500 companies have adopted Second Chance, hiring policies specifically for youth who experienced courtroom trauma. This corporate involvement reflects growing recognition that healthy communities require fair legal systems. Business leaders increasingly view judicial reform not just as social responsibility, but as economic imperative, understanding that children who experience justice system trauma often face lifelong barriers to employment and productivity without intervention. The case attracted global scrutiny, with international media framing it as emblematic of broader American systemic issues. Comparative studies now feature prominently in policy debates, highlighting that most developed nations prohibit public humiliation of child defendants. The United Nations Committee on the Rights of the Child cited the incident in its latest report critiquing U.S. juvenile justice practices. Conversely, some nations facing similar challenges have drawn inspiration from the reforms it sparked. This international perspective has proven invaluable, offering proven alternatives to adversarial approaches and reminding American reformers that creating child-friendly legal systems isn't just idealistic. It's eminently practical and already achieved elsewhere. 2 years later, researchers have established concrete metrics to assess reform effectiveness. The newly created Judicial Wellness Index evaluates courtrooms on factors like child comprehension levels and participant anxiety measures. Early data shows promising trends: a 38% reduction in child distress indicators during proceedings in reformed courts. Most heartening are the personal stories, like the judge who now keeps stuffed animals in her chambers for young visitors, or the prosecutor who instituted explanation breaks during child testimonies. While systemic change takes time, these measurable improvements demonstrate that even centuries-old legal traditions can evolve to better protect society's most vulnerable members while maintaining justice and order. Law schools nationwide are fundamentally restructuring clinical programs following this watershed case. The revised curriculum emphasizes developmental psychology, trauma-informed interviewing techniques, and alternative dispute resolution for juvenile cases. At Columbia Law, students now participate in reverse moot court, where they must explain complex legal concepts to groups of elementary school children, a humbling exercise that builds essential communication skills. More remarkably, 30 states have amended their bar exam requirements to include juvenile justice competency components. This educational transformation ensures future attorneys will enter practice equipped not just with legal knowledge, but with the emotional intelligence necessary to protect young clients' well-being while navigating adversarial systems. Early career attorneys report these changes are revolutionizing their approach to juvenile cases, viewing children not as problems to be processed, but as individuals requiring specialized advocacy. What began as a shocking viral moment has matured into America's most significant juvenile justice reform movement in decades. The case exposed systemic flaws, but also revealed our collective capacity for meaningful change, proving that even entrenched legal traditions can evolve when confronted with undeniable human consequences. Courtrooms nationwide now implement child-sensitive procedures. Law schools teach empathy alongside case law, and communities have developed robust support systems for families navigating legal processes. Most importantly, the conversation has permanently shifted from whether children deserve dignity in court to how best to guarantee it. While work remains, this painful chapter demonstrates that justice need not come at the cost of compassion. The legacy endures not in continued outrage, but in thousands of daily acts. A judge kneeling to speak eye level with a child, a public defender using stuffed animals to explain legal roles, a law student choosing juvenile advocacy, that collectively rebuild a system worthy of the vulnerable lives it impacts. True justice, we've learned, must always make room for humanity.